Okay, welcome, folks. If you want to put a quick introduction in the chat, that would be really helpful just to know kind of who we have here with us today. If you just want to say your name, any institutional affiliation, or the kind of work you do, and maybe a fun fact about yourself in the chat. Um, we'll look forward to those. I'm Shana Hollick. I'm the Learning and Training Manager here at Creative Commons. I live in Gettysburg, Pennsylvania. And I'm a professional classical musician when I'm not at work. That's always my fun fact. I play the French horn. Uh, what I'm going to do today is introduce Meredith Jacob. Meredith is the director of the project on copyright and open licensing at the Program on Information Justice and Intellectual Property at American University, Washington College of Law. She is a co-author of the Best Practices in Fair Use for Open Educational Resources, which is a really cool document we're going to link to in the chat later. You can also find the link on our questions document. And the public lead for Creative Commons United States. Her other work includes serving on the steering committee of the Open COVID Patent Pledge and the Low Carbon Patent Pledge. And there's probably a bunch of new things that Meredith has done since I've written that intro. But I'm going to let her add anything to her introduction if she wants, and get started. She's going to kind of lay some groundwork for us, talk a little bit about just some general things, and then we're going to open it up for Q&A. So thanks, Meredith.
Hi all, thanks for coming today. My name is Meredith Jacob. I'm a lawyer at American University's Washington College of Law and the public lead for Creative Commons United States, and happy to have all of you today. And the first thing, as Shannon mentioned, that we're going to talk about is just the real tension, I think, that comes up when folks like all of you who've made this big investment to know more about the Creative Commons licenses and to know more about copyright are out there in the real world doing your work, and people ask you questions and you want to give them meaningful answers. And I think people are often stuck between two compelling but conflicting sort of goals. One is you don't want to give them legal advice, right? Because in almost all these situations, you are not their lawyer. I don't give people legal advice because I'm not your lawyer. You know, I am a lawyer. And most of you shouldn't give legal advice because you're not their lawyer and you're not a lawyer. Some of you are. But mostly you are not giving people legal advice. And when you say giving someone legal advice, that means giving them fact-specific legal advice, saying, yes, if you do this, it is legal. No, if you do this, you won't. The things you can do, though, are give people legal information, right? This is what I think the law is. You can give them examples and hypotheticals. You can give them cases that you know other people are actively doing. You can say, this is what I do in my own practice. And I think, you know, realistically, you can come up into this sort of areas where you're like, I think this is an area of higher risk. I think this is an area of lower risk. But fundamentally, what you cannot do is say, yes, you can definitely do that. It is definitely legal. Or no, you can definitely not do that. It is definitely illegal. That is giving people legal advice. And so you want to avoid doing that. And you want to give them legal information. You want to give them examples. You want to give them all of the other stuff that gives them enough information and enough sort of touch points to make that decision effectively themselves. And it's pretty hard, really, because you want to help people. People are coming to you. You're in a position of expertise or sort of positional authority, and you want to say, yeah, you can do this, or no, you can't. And I think the other part of this that is really hard, and I want to counsel people to avoid, is to not just then basically default to giving people hyper cautious legal advice. Because I think one of the things we see out there in like the practice of the world is people hear that don't give legal advice and they're like, okay, yeah, all right, no legal advice. But that sort of gets internalized as don't give people legal advice that says yes. But what I think a lot of folks do is they default to just giving legal advice that says no, right? They're like, oh, I don't know. I can't tell you you can do that, which sort of has this default outcome of being like, no, you can't. And so I would give you these two pieces of advice that are a little bit in tension, which is you can't be their lawyer, but don't tell them no, right? That we shouldn't have a situation where we interpret the real and useful guidance of don't give legal advice to mean tell everybody no all the time, because there's real mission risk to basically de facto giving people legal advice that says you can never do anything new. You can never do anything that has any tiny amount of risk. And so I think balancing those two out, where you aren't sort of going in and saying, yes, I substitute my judgment for yours, you can definitely do that, right? Because that's what the legal advice is saying, I'm using my judgment to tell you yes. But what you should do, I think, is use your information, your expertise to help them feel confident in their judgment of yes or no, right? And so those two things are they're sort of in tension there. But I think it's important not to give legal advice, but also not to have it be just a sort of lowest common denominator of the least risky things anyone can imagine. I'm just reading the comments to see. Yeah, to see here. And I think this applies to both CC licensing and fair use. You know, in fair use, I think there's the common sort of refrain is, oh, I don't know, you could get in trouble. And the answer is like, you can get in trouble for anything, right? And you should be more worried about getting in trouble for not doing a good job teaching your topic, for not covering the stuff that you should cover, and a little less worried about getting in trouble for like the sort of lowest tier of copyright risk. I think we also see this in the context of CC licensing, this hyper caution where everybody can imagine the bad actors, you know, and we're going to talk a little bit later in this session about the CC BY NC licenses. And this is not, this is my own opinion. This is not the, you know, canon opinion of Creative Commons as an organization, but I think a huge amount of the adoptions of NC licenses are people who fundamentally want a no bad actors license, and that for better and for worse, we do not have a no bad actors license. And so, you know, I would say when you are picking your CC licenses, focus primarily on the good things that you are going to be enabling other people to do with your work, and focus less on the no bad actors work, in part because the CC licenses have two functions, right? They have a legal function and they have a community function. The legal function is that in theory, if someone ignores your CC license, you could sue them. In practice, most people in this community are not suing people for copyright infringement for licensed or not licensed stuff, right? Like it's just not a thing that educators do very often. And so for most people, the actually suing someone in federal court is a relatively unlikely thing, license or no. The other is that it communicates to people in the community, this is what I'd like you to do. And so bad actors aren't listening to that communication. And in many cases, they're just straight up infringing other stuff. And so I would just say broadly, that hyper caution that we see about copyright also extends to licensing, where people are either hesitant to use a CC license or choose a more restrictive CC license because of a sort of worry about the unknown. And I would encourage folks to just to accept that like there is always that outlier risk, but that it is more important to focus on building community and enabling people who are working towards the same things as you are. So that's my spiel about legal advice and risk. I'm sure everyone here has had examples where people have come to them and been like, can I do this thing? And I wanted to see if anybody had an example about can I do this thing that they wanted to talk through, either in terms of the ultimate answer or in a little bit of sort of back and forth about how you could frame giving them empowering information without giving them legal advice. happy to do that in chat, or if someone wants to unmute. Nobody, huh? No one's ever been asked that.
I was like, I've got one if no one else does. I used to have faculty ask me questions all the time. Um, can I copy the first 3 chapters of this textbook and put it up on Canvas for my students to access?
Yeah,
It's only a few chapters. Can I do that?
right. And so that's a question that so the first question that I always ask you when you say, can I do that, is why do you want to do that? Right? Because if we're thinking through fair use, the first question is, you can't answer the question of do you have a transformative use if you don't know why you're using it. So why do you want to put those up on Canvas?
Well, we're only using a few chapters, so I don't want to make the student buy the whole book.
What are you using those chapters for pedagogically?
Oh, they're really vital to this section that I teach about cool stuff.
And are you teaching about the same general subject that the textbook is taught about?
Uh, Sort of, but my course really focuses on XYZ and the book really focuses on this other thing, except for these couple of chapters. So that's why I like to pull those out.
Okay. Well, so when I make decisions like this, what I often do is I try to use a framework for thinking about fair use in the context of education. I use the best practices in fair use for OER. In my read of that best practices, what I see is I think the link, I was just checking, I think the link on there is broken. I will find you, like, when they migrated our website, I think they linked to a picture. I will find you the link and put it in chat, just as an aside. But what you have to think about is, are you using those for the same purpose they were originally written? And so that page works. The link for the document on the page does not work. Sorry, as the aside. But so what I would say is, I think it looks to me like that might be sort of the same purpose that chapter was originally written. Like, does that make sense to you? And sort of go down that route. The interesting thing is that chapter example is used a lot. Chapters are generally, it really depends. Multiple chapters of books that sort of fall into the same general topic, like we are teaching, they might be used for the same class, multiple chapters like that. Those are going to be the really hard fair use cases. I think they're often not going to be fair use. But as an example, there are purposes for which those chapters could work. If you were teaching a history of science textbook, right? You were doing, I'm teaching history of science, and I'm showing you how the way we taught immunology has changed over the last 60 years. You could absolutely use those chapters, all 3 of them up there on Canvas, to say, this is an example. We have 3 sets of chapters. We have chapters on immunology and cellular communications from 1950, from 1980, and from now. And we're comparing those, right? So in that situation, using the same amount of text might in fact be a fair use. And so in that situation, what you're teaching is really different than what the chapters were originally written to teach. That's fair use. And so then I think you'd have to leave it up to the person to make the ultimate decision, but you can sort of show that whole framework. Oh, you found it. Thank you.
Yeah, and I'm like, we're getting a lot of good questions in the chat already.
All right, let me read those. I can't talk. I can talk and read at the same time a little, but
no, I got them for you. I've been
okay.
I've been
We have
keeping
an
track.
academic who is publishing a book, open access, and is worried about taking their research to create something saleable, and so is struggling with a license, even though the funder suggests CC buy. Good news, bad news. Doesn't matter. So on that one, if what they are worried about is someone creating something saleable with the ideas in the research, copyright does not protect ideas. So I might be misreading that question, but it sounds to me like they've done this research. and they think there is some commercial product, like maybe an evaluation tool, maybe an invention, maybe a method of teaching. Elisa, if you want to talk more about what it is, we could talk about that. But for better or worse, copyright only protects the expressions written down on the page. So you can't protect ideas or ways of doing things or discoveries or independent research or any of that with copyright. So the only thing you own in copyright is the sentences, basically, is almost the word choice. You want a little bit of the like sentence arrangement and flow through the narrative, but only at a pretty like fine detail. So cases about this in the past have included cases like one biographer of Abraham Lincoln had basically not done a lot of original research and had sort of used a lot of factual information from a different biography. And from an academic standpoint, that might be something where you need to attribute. It might be even into the space that's unethical, or it might just be like poor and uninteresting scholarship. But from a copyright standpoint, copyright does not care about that. And I think that's important to differentiate. Everybody has very discipline specific ideas about what is the correct attribution, what is meaningful research, how do we do a citation? And that's meaningful in a discipline, but it's unrelated to copyright. And even within disciplines, right, it obviously varies based on the formality of the writing. The amount of citation you do in a peer-reviewed article versus the amount of citation you do in like public press versus what you do in a textbook versus what you do in an email is always going to be different. But back to the question about the scholarly monograph under OA or the article, if they have, for example, a method to do cognitive behavioral therapy, or they have a method to do accounting, or they have a new way to rotate crops while they plant them to get better yields, or they have a way to, I don't know, decaffeinate coffee. All of those things are not ownable under copyright. And even farther, to the extent that there is only one reasonable way to describe them, that description is specifically protected under a limitation and exception to copyright called merger. So we have two ideas in copyright. One is idea expression, right? Which is, it says the idea is separate from the expression. You cannot use your copyrighted expression to own that idea. And that's a fundamental sort of limit on how copyright functions. And then within copyright, there's a second thing called merger, which says if there is only one, if there is a sort of reasonable functional way to express things, even if in theory you could engineer around it, if the language is really functional, you can't own the functional stuff by owning the language. And that's often talked about in the context of things like accounting forms or analytical rubrics or the language and arrangement of computer menus. So there was an early case that basically said Microsoft can't own the standard file menus at the top of like a Word document, that those words are functional, even though they're arranged together, you don't get copyright for that. So I'm going to read a couple more questions. And then
I just want to give a quick comment on that. Like some of the questions I get about CC licenses and sort of the perceived risks of CC licensing your thing are really, they're not risks of the licenses or of copyright. They're kind of just risks of being a human being living in a society with other human beings. So even if I publish my monograph or my article fully closed and it's behind a paywall, I mean, the very act of publishing means that somebody has access to it and can read it. You know, they might have to pay for it first. Okay. But yeah, they can read it and then they can go take those ideas and like do things with them. And some people really see that as a risk. And the interesting thing to me is that, well, the whole point of scholarly publishing is that that's not a risk, that's an opportunity. That's why we do scientific publishing, is so that people can take our ideas and do things with them and build a discipline and, progress research forward. So I always find those kinds of questions really interesting. Just to save you some scrolling, Meredith, the next question that I saw in the chat was about, can a course host a public film showing that has a panel discussion portion before or after the film? So it's on campus and admission isn't charged. They ran this by their university legal counsel, who said no unless the students paid licensing fees, even though the library had a version with public performance rights. So now we're getting into like, can I show a audiovisual thing and in what contexts?
Well, if you had the I like, to be honest, I don't have enough. That's like too specific a legal question. Like, I would
Mhm.
have to understand what public performance the rights the library had paid for. Um, that would be like a question of what they had paid for there. So unfortunately, I can't. I would need to know more about that. And interestingly, that is a question that falls really into the I can't get, even if we had that information, where I'd be like, I can't give you legal advice about that, because it's like, that is, read the library contract, think about the facts, and then tell you yes or no. So that's a situation where like it would come down to what the what the public performance rights they have contracted for said.
Mhm.
And then like, I don't know whether what the university council was looking at was like, maybe they had contracted for public performance rights to students and if this was open to the public. Um, what I will say is, um, it's a different question if you're saying I'm showing some, or in some cases, even all of this film as part of a different purpose, right? If you're like, this is a film showing with some discussion, that is not a fair use question. That is a public performance question that comes down to like, what are the terms of the license that you have in public performance, all of that. If instead what you were doing is we're doing a full day panel on a full day symposium on media, war, and miscommunication. And so you showed a couple of films in the context of that full day in which they were contextualized and discussed. That's a space in which you might have a fair use argument to be made. Um,
Yeah. I'm actually going to jump to there was a question because this gets back into a little bit of the fair use thing. And in the US, there's this standard of like if a fair use is transformative, that really changes the calculus. Does that work outside the US? Do you know? Like,
so yeah, so there's different countries have different, all countries have limitations and exceptions to copyright law. So almost all countries, there's like 3 countries that aren't signatories to the Berne Convention. They are not particularly economically or culturally engaged. They're like, I can't remember. They are countries that are not signatories to like any of the UN conventions. So everybody has copyright law and everybody has limitations and exceptions to copyright law. Common law countries, so the United States, Canada, the UK, sort of Australia, New Zealand, they are common law countries. They're a little bit differently structured. Interestingly, Israel and also has fair use. So United States, Israel have fair use. Common law countries have fair dealing. Fair dealing in Canada uses a slightly different legal rhetorical framework. But in the best practices in fair use for OER, we explicitly did US international and then also specifically US Canadian appendices. And so our conclusion was basically that everything that is fair use in the United States is also fair use for educational purposes, like covered by that guideline, right? So everything that's under the best practices in the United States, almost all of that is fair use is fair dealing in Canada as well. Canada had these big 5 copyright cases they call the pentology. about educational fair dealing. And so US and Canada are pretty overlapped there. In the UK, the quotation right is pretty powerful. And so it's not the same analysis. It's not, is it transformative? But the quotation right is pretty powerful in a lot of other countries. And then civil law countries, which are European countries and countries whose legal regimes line up with them, have a set of exceptions that include quotation, but also include things like private study. And so, or some of them have education. And so there's gonna be, if you're in other countries, what I would say is between quotation and private study and things like that, it's really hard to construct a situation where an individual user of a textbook, like somebody who just downloaded it and was using it in another country, that there was any legal risk for them. If you are in another country and you want to republish and sort of redistribute a textbook, right? You're going to be like officially adopting it or something. Then you need to go through and think through the examples that are used under fair use and figure out whether you think they are also available under your national law. But all legal structures, all copyright legal structures have space for quotation. It's how broad or narrow that quotation right would be. I saw a question in here about photographs of things in the public domain.
Yeah, that was the next one
This
on
is
my
like,
list.
I think we post this publicly afterwards. I don't know if it's just for the CERT members or is it on the open web. But
We do tend to post them to our YouTube channel now,
yeah,
so they are
but
publicly available.
so I'll be polite in my language. This question is frustrating to me. So there's a couple of cases in the United States that seem to fairly conclusively suggest that just because you took time and money to do something does not give you a new copyright ownership right, right? There's a sort of legal rejection of the theory, if value, then right. Just because something has value does not mean that you have a copyright ownership in it. This is immediately obvious in the idea thing we discussed earlier. You could have a really valuable idea, right? You could have an idea that would make people way more successful in some important task in their lives, but that doesn't give you a new copyright interest in that idea. You have it in the original expression, but you don't own the idea. And so similarly here, there is value in those photographs, but if what they are is just a careful and faithful reproduction of the public domain work, at least in the United States, there is not a new right in that. That does not mean that people will not try to charge you money for it. You can go online if you would like to, and you can search all the big image houses, and they will happily charge you thousands of dollars for different commercial licenses to things that were created 1,000 years ago, right? There is no way they own that. They do not have any ownership right. They often do not even own the image. They're just like, oh, I got it. You want to pay me for it? It's similar to saying I could stand in front of my house with a sign that says, you have to pay $1,500 to take a picture of my house. And in the United States, we are very, very clear that is not the law. But if people pay me, they pay me. And so, you're stuck in this sort of bifurcation where, if there's digital rights management on the image and people assert that they own it, it's not illegal for them to charge money for it. But I would say it's unethical. And one of the things that I do in work with museums and other memory institutions is to encourage them not to sort of adopt that extractive commercial practice. If you have materials that either you own the copyright for or they're in the public domain, then high resolution scans of those images should be free. But that's my soapbox on that.
It's a good soapbox. The other question, I think the last one I have for now. So do ask more questions, and if there's follow-ups on any of these, feel free to add them. But there's some discussion around, can an educational institution use a non-commercially licensed text in a course when the institution charges students tuition to take the course? That's part one, and then there's a part two, but let's start with part one.
So that is the law is the law, people are people. So non-commercial is defined in the licenses, right? But the licenses are interpreted in theory by courts, but primarily by people in their regular practice. And in the United States, I would say there is no meaningful disagreement about whether or not you can use CC BY NC materials in tuition-bearing not-for-profit education, right? I would say that no one in the United States meaningfully argues that if you're at, a regular not-for-profit educational institution in a tuition-bearing class, everyone thinks it's fine to use CC BY NC materials. You will find people in the OER community and in the Wikimedia community, in Germany, for example, where they are like, no, you absolutely cannot do that. And part of that is that those are countries in which higher education is, in many cases, not tuition bearing, right? And so they're like, you're there charging $30,000 a year for college and you want to use my NC materials for free? And so I think in a lot of ways that what is non-commercial reflects the larger sort of societal reality of that. The separate thing is also those licenses are going to be interpreted by courts in different countries. So in the US, there is a case about this, about K through 12 schools having materials printed at Office Depot and FedEx. And in that situation, the court said the schools are not commercial users. In this case, they were public K through 12 schools. And the office companies are just basically agents for those schools. But to me, this is actually a cost of using the non-commercial license, is that people are going to be cautious about whether or not they can use it, and that it doesn't give you a sort of guaranteed outcome. Particularly because it doesn't come into, the question is not, are you a commercial actor? The question is this a commercial use? So you could be a huge for-profit commercial company, and you could distribute a CC BY NC article that was like a scholarly publications article that was under CC BY NC that you thought was like really important health and safety information for everybody in your company. And so you at like, ExxonMobil, OpenAI, BlackRock Capital could send that to everybody in your company to be like, hey, this is an important update about this like safety issue or this emerging technology issue. And I think there's a really strong argument that's not a commercial use because you're not using it primarily for commercial advantage, which is what it says in the license. So, and the flip side of that is you could be like a, public pre-K through second school. And if you used a CC BY NC image on your fundraising calendar, I think you could argue that was a commercial use. So that is not a no bad actors license. And so it's why I don't recommend it. I mean, people choose it, but I don't recommend it because I think it causes more trouble than it prevents. There's a second part of the question which says, same question, but the institution is bound to an inclusive textbooks model where the students pay a flat rate. I don't think that really changes it. I don't think that second one changes the NC license meaningfully. Like, I think you're not paying for that specific thing any more or any less. I mean, this is not a question that is answerable, I don't think. Like, it is a question of like sort of community standards and norms, and a question that could, I guess, eventually be answered by a court. But I just don't think there's enough information in the law or in the license to give you a very firm answer to that.
Yeah, and those sorts of inclusive access models and equitable access
Yeah,
models have all sorts of issues wrapped up in them, but
they're
they're kind of
bad. I
less
mean, this is
issues
like
about the license than about
there's a
just how
lot of
bad they
problems out
are.
there that are not about license. People, I think, because copyright and licensing are relatively enforceable, there's this tendency to try to use copyright and licensing to solve problems. The follow-on question, where you said, I've seen bookstores charge for a digital OER. That is a wild situation for me. And I think that one is both very bad practice, and I would want to understand why they were charging for a digital OER, which feels to me pretty unethical. And then also there, that specific, you were charging for a digital OER that was CC by NC. That one would be, to me, a much stronger case that you were violating the license. The only situation in which I don't think I would feel that way is, bookstores regularly charge. I think there are many universities that have come to the settled practice where bookstores might charge like a flat commodity rate, like cost recovery for printing CC by and C OER, where like, you know, our print rates are 7 cents a page. If you want this 100-page OER, that's $7. Like that, I think is fine. And I guess in theory, you could construct a hypothetical where bookstores charged a nominal fee of like $1 or a couple dollars to like load and host documents in their LMS. And I would find that ridiculous, but maybe not violating the NC license. But yeah, that's a really interesting one. And honestly, I would be interested in hearing more about it because I think it is a problem.
I mean, if anyone has that sort of situation and wants to share a little bit more, I mean, we have time.
I mean, the other question that's discussed there, which is you pay the inclusive access fee, whether you're using the books or not, is a real big structural problem. And I don't think is
Yeah.
like an NC licensing problem. And unfortunately, legally, I don't think the licenses are a solution to that. I think from a policy standpoint, OER is a solution to that. But yeah.
Yeah, no, it feels like essentially a tuition increase under another name, right?
Yeah. There's so Michelle asked a question that says they have an OA journal, their
Mhm.
articles are under CC, they get permission to use art that's copyrighted. We reprint the art that's not CC. I think you just make it clear. This is a clear communications question. You're doing the right thing. And so I think just make it clear in the front matter of the journal where you list the licensing, and then at the image itself, say, this article is under a CC by 4.0 license, except for included images, which are all rights reserved, copyright to their author, and included here with specific permission for use in this article. I put that in the front matter or something like that, whatever you thought communicated it most effectively. And then I'd say, I might include a sentence if it is, which I think should be true, which is you can reuse this article intact, including those images, but the images cannot be used, but you need separate permission to use the images separate from this article, right? If you thought that was useful to communicate, and I'd be happy to talk to folks about model language for that. So let me write that down on my list of model language.
Yeah, I think a lot of times folks are looking for, well, like, what's the right way to signal that, or what's the right way to communicate this thing and that thing? And a lot of times the answer is just like in a way that is clear and understandable to your users.
Clear, understandable, and context specific, and sort of like makes sense in the context of how you're doing your work. Michelle, so for Michelle or anybody else, I'm gonna put my email in the chat. you email me about that, I'm happy to get some model language. That's part of the work we're trying to do, is have model example language. Um,
That's awesome. Yeah, and Meredith, if you end up with anything useful, feel free to send to me also, we can
yeah,
share.
absolutely.
Um,
So Melissa asked a question about updating the CC licenses.
yes.
You can absolutely update them. You just end up with two. You end up with the old one out there, sort of ghost ship, and the new one functional. And so this is a good thing to do. The licenses are changed. I think mostly in a not meaningful way. People get worried about compatibility between old licenses and new licenses. There are some meaningful things there. I don't think there's a lot of them. Primarily because, as we said before, licenses are about communicating intent. They're not like the vast majority of the CC licenses are never sort of technically analyzed or litigated, so it doesn't matter very much. But it's good to update them if you have it. And so I would say you absolutely can. You can have parallel licenses. So it's possible for you to put an article out under CC by 2.0. That license just exists. It's a ship in the night going forward, right? Then you put it out under CC by 4.0. That license exists from the time you put it out. Then, if you wanted to, if someone wanted to use your stuff like white label and not attribute it, you could write them a commercial license. All those licenses can exist at once. So there's no problem with doing it. A thing that also comes up like in conjunction with that is in that license information, you can put, if you have like a good stable URL, you can put that there that says, hey, for updates or new versions, here it is. And so people who have the 2.0 version, if you would put that in, then you could find the 4.0. But yeah, just relicense it. There's no problem. They both exist. No one cares. What you can't do is into the 2.0, but you can have 2 and 4 happily.
Um, if we want to revisit this, I mean, Anne Marie offered to chime in a little bit about that charging for digital OER question that actually happened at their institution. So I don't know if we want to
Yeah,
open that
I'd
up
love
for
to hear a little bit
discussion.
about that. I think that's a, unless, so I'd say that's a really big, important topic, and I'd be happy to talk about it here. I think it's also a big enough topic that it might be worth opening up to a couple other folks to see who wants to talk about it. But why don't we, yeah, if you want to talk about it for a few minutes here, that'd be great. But I also want to see if there are any other questions for folks who are on the chat in other topics that we hadn't addressed yet.
Yeah, I don't have any other questions in the chat right now, so I'm happy to open the floor to Anne Marie or Carrie Ann also mentioned this happens at theirs. I will also give a quick shout out. After you successfully complete the course, you'll be invited to our certificate alumni community. And our next alumni meeting actually is going to talk a little bit about this because it's a very, very common issue that folks are dealing with. But yeah, I'm going to stop talking here and let Anne Marie go for it.
Sure, thanks. So I just noticed this at my institution. It's the first time I've noticed it. It wasn't related to an inclusive access model. We do have that, but it wasn't in place for this particular course. So it was an intro to psychology course. One of the sections, the instructor was using an OpenStax text. In their syllabus, they provided the link to the free digital OER. Our books, and they reported it to the bookstore like we ask them to do, because that's how I get all the OER adoption data. And our bookstore listed it as an access code and charged about $45 for it. I'm guessing, I'm still looking into it and asking other folks to look into it, but I think it's because it has an ISBN, and something about the Follett system charged for something that had an ISBN. That's as far as I can tell right now. I hope it's like an isolated incident, but I need to spot check other OpenStax texts and other OER that have ISBNs.
Yeah, so that's there's a couple of possibilities there. It's possible that somehow that 45, there are as I'm sure you already know, but just like to think through the possibilities. There are hardbound commercially produced versions of the OpenStax books. So you can buy, I don't think I have any at home, but you can buy like, they look like commercial textbooks, they're hardbound, OpenStax books. So it's possible that they carried that print price through. There are also OpenStax commercial testing and ancillary materials. So it's possible that they incorrectly were selling seat licenses for those. But I would say as you're digging into it, also email me and I can connect you with some of the folks I know at OpenStax. I think they'd be very interested in that problem as well.
Will do. Thank you.
So yeah, if you
Yeah.
send me an email, we can follow up about that.
Yeah, fascinating. We did get a question, and this reminds me, if you have a question listed on the document, and you're actually here in the room, do let us know, because we'll pull those out and prioritize them. So this is one from the document, but Anna's also here, and it's really about the difference between linking and copying. So if you link to an image online, as opposed to like copying it or saving it or downloading it,
Yeah.
is that a copyright thing? Like what's going on?
I also have opinions about this. So generally in the United States, right now, linking, it doesn't implicate copyright. So, you know, you can link to anything. The exceptions to that, and the reasons I'm sort of like being slightly, if you link to something that you like affirmatively know is infringing, there are a few edge cases where people are starting to find liability for like linking to content. Like if you were like, here's a link to this full text textbook at, you know, Pirates Are Us, this is definitely pirated, don't tell people.com. And then there's been a few cases about that were actually about commercial sources embedding what was not licensed content in their webpage. So it was like this sort of dual layer of it was embedded and showed up as content, and the site it was embedded from was infringing. So like 10 years ago, I would have told you linking is always 100% not infringing. Now I would say if you're a commercial actor in a bad actor posture, possible, but even there, I think it's super unlikely. So I think linking in educational contexts without, I'm not saying you have to verify the source, but if you just don't like, if you're not like 100% sure it's pirate, like if it's not your problem. So if you're in educational context and you don't have like explicit bad actor intent, I don't think linking is a problem at all. Even if you do, I actually don't know of any cases that say that it is. I just wouldn't do it. The thing I would say about linking though, so it's not fair use because it doesn't reach copyright. You only need fair use if the thing you're doing is otherwise limited by copyright. So you don't need fair use to read a thing because reading is not limited by copyright. And so like I think that part's clear. The thing I would caution about is that linking is sort of medium useless. And so that stuff goes away. The URLs die. You aren't controlling whether or not there's alt text on that for your students with disabilities. And so linking is very easy, but in that context, I would also go through the effort of looking at the fair use analysis and figuring out whether or not you could use that. So it's hard to tell, but I didn't read the website. Is it fair use if you link to an image online from your library catalog? So the image is hosted on like the publisher site and you're putting it in your library catalog. I will say I think it's definitely, there are cases in which that is fair use. If it's just in like broad everything in the catalog, I'd have to like think about that a little bit more. And so maybe in this situation, And if you want to tell me more about the context, I could answer more on that. But like, if you were talking about anything about the cover itself, then that's a situation where it becomes more and more likely that that is fair use. So what's the purpose for linking to the image? Just so I understand.
We're getting some more info in the chat.
Thank you.
Yeah, a lot of library catalogs do this, right? It's essentially to make the catalog look pretty.
Yeah, so look pretty uses are going to be the least fair usey. But even there, it depends. So if this was like a chemistry textbook, right? That's like introduction to chemistry, and it has like a picture of two beakers and like a crumbly white metal, your fair use case there is pretty low, right? Like there's not a lot of new value provided to your book finding aid. But if there's something really something that really adds meaning to like which book are you finding in that cover, that's where you start to be able to make that fair use analysis, right? So I could imagine 6 books that all have the title modernity, that are about art and about agriculture and about domestic like families and household living or whatever. And in those contexts, if they had like really evocative covers, that might provide new meaningful information to people who are going to choose to borrow that book and to sort of find it. And so there you might say, like, you might be able to make that case. It's complicated. This is a case that comes up a lot. We've talked about it in a couple of specific situations. I will put it on my list. One of the fun things about these is it's when I get things on my list of like short guides or model information we should do. And so I will take this as one under announcement. The question of like, does it make people, sorry, I'm just writing things down. Does it make people more likely to buy it? Therefore, it's like a positive marketing effect. I don't think fair use really talks about that. Fair use, when it talks about the market effect, is really like, are you substituting for the original or not? Like, is this a thing that when they put it out there, people are going to pay for or not? That question to me primarily goes into the space of it being fair use to use the cover. As like sort of a nominative fair use, like you're showing it as a way to explain which book you're talking about. I don't think there's a clear answer here. I'll work on it. But the question of like, it helps them, so it's fair use, is not really how that legal analysis works. It might 100% be how that risk analysis works, but it's not how the legal analysis works.
So thank you. We have time probably for one more question. I don't think I have anything else in the chat, although if I missed something, let me know. But yeah, last minute questions for Meredith.
Thanks all. Please do, so the I put my email in the chat. I'll put it again in right now. If you have any questions, particularly about like resources or cases that like, hey, if we had clarification about this, it would open up this little area of practice, please send them to me. And thanks again for all your hard work helping people understand the licenses.
Sorry,
Have
I
a
was
great
muted.
day.
Awesome.
And I will talk to everyone hopefully again sometime in the future.
Yeah, thank you so much, Meredith. Thank you for taking the time. Thank you, everybody, for asking your awesome questions. And thanks, Meredith, for sharing your email in the chat. And we're going to do this again next week, where we'll answer some more questions, maybe some of the ones we didn't get to today, get a different perspective from CC's Copyright and Licensing Council, Catwash. So hopefully we'll see you again then.